I'm Magistrate Kogan. I'm a Child Support Enforcement Agency magistrate. So I'm considered a juvenile and domestic magistrate because we cover both types of cases. How many attorneys do we have in here that are, okay, everybody, cool. And does anyone practice in domestic and juvenile court? Does anybody ever? A little bit. Okay. So this might be helpful. I thought this was a really basic bit of information, so maybe since you guys don't practice in there regularly, this will be helpful. So our court handles, to start on the domestic side, we have two courts that are combined into one, domestic and juvenile. The domestic court handles, obviously, divorce, dissolution, child support, and custody matters, and then the juvenile court handles the delinquency, abuse, neglect, dependency cases, but also the custody-only cases and establishment of paternity. So those would be never married parents, and those cases are considered juvenile court cases. The only difference technically in the clerk's office is that the domestic court cases are public record and the juvenile court cases are not public record. So if you're looking to look something up on a juvenile case, you, as an attorney, you just have to sign in and indicate that you're an attorney on the case, and that way you can get access to those records, but the general public cannot do that. So how many people have ever done a domestic case? Okay. So that's why you don't do it anymore, right? Okay, cool. Well, in case you have like a cousin's, grandchild comes to you and says they need to get a divorce, this might be helpful in case you need to do it again sometime. So divorce cases are contested in nature. There's a complaint that gets filed just like any other complaint. There's 28 days for answer and counterclaim, and then it's set for a contested hearing. Usually that's in front of a magistrate. They'll set for temporary orders if that's necessary, if there's a request for that. The dissolutions are uncontested, so the parties they can't be represented by the same attorney. Oftentimes one party will have an attorney, or they can both be pro se, where they prepare all the paperwork. Everything's done before they file it. They have their separation agreement. If they have children and they want a shared parenting plan, that's already agreed on. They sign everything. It's all done. And then they file that with the court, and then the law says that they have, it has to be at least 30 days after they filed it and no more than 90 days after they filed it. So in that 60-day window is when they have to have their final hearing. That's just a jurisdictional issue. So once 90 days has passed, it has to be dismissed and refiled if they want to continue to proceed. And you can't set it for earlier than 30 days, kind of like how they make you wait this long to get married when you get your license. So the dissolutions, and they have it, there's a checklist, and this could be helpful to you if you ever do one of these. There are two checklists. I got the checklist from Judge James Brown because his is the most comprehensive that I could find, and he agreed to have me share this. So this checklist can really be helpful if you ever just are ready to file a dissolution. You want to make sure you have all your ducks in a row before you file it. One's with children and one's without children. So the two checklists, that's the difference between them. So there's just a different bunch of affidavits you have to file, different statutory requirements that you need to address depending on whether or not there are children in the case. So those checklists are super helpful. You'll get one if you ever file a dissolution. You'll get one that says you didn't file this, you didn't file that, and make sure you do this. So that's really helpful. The staff attorneys typically fill that out. I think actually Judge Brown's secretary is the one that does this because she's been doing it so long that she probably could be his staff attorney. And so I want to know, does anyone have anything that they wonder about, or they've done a divorce and they thought, why did they do that, or they have any questions about it that you want me to address before we move on to the child support issues? Yeah.
So I do have a question. Whenever a dissolution is filed, you mentioned that there are several affidavits, and one of them is a death, but about income and death affidavit.
Correct.
Do the party do they have to file separate ones?
Yes.
Because they have their names on the same form, but still do they have to have separate ones?
Yeah, so they have to have separate, so that's their affidavit, their testimony of what their assets and liabilities are and what their income is. And so they're testifying, yes, I have a gold ring in my house, and the other person will say, oh, I didn't know you had that. You know, I mean, they have to make sure that they are independently testifying as to what their income and their assets and liabilities are. So yeah, that's a good question. Anybody else? Okay. So I worked in the area of divorce, dissolution, and then juvenile law up until I became a staff attorney. Then I continued. Come on in. You guys, if you want to sign in, I don't mind if you come and sign in, even though you're late. I don't mind if you're up here doing that. And then I became a magistrate that handled all domestic matters. And then in the last 8.5, 9 years, I've been what's called a child support magistrate. And so this is information that most people don't know. It's sort of, you don't really need to know it, but the Child Support Enforcement Agency is a state agency, an administrative agency, and they provide the funds for the court here to have 3 magistrates that only do cases that involve the Child Support Enforcement Agency. And so while we're domestic and juvenile magistrates here at the court, we're a little bit separate from all the other magistrates in that we're funded in a different way. It doesn't change how we do our cases, but it does mean that we don't take other types of cases. So our contract limits us that we're not allowed to do any custody matters. We're not allowed to do any privately filed cases. And so that's where you'll get into people will file a privately filed case and they'll accidentally set it in front of one of us and we'll say we're actually, it's not that we don't want to do them, we actually can't do them. So contractually we'd have to send it over to another juvenile custody magistrate or another domestic magistrate. So little tidbit of information you don't really need to know, but it's kind of interesting. So the child support can be established through the Child Support Enforcement Agency or in the court. And so in the court it can be established by someone filing a complaint for allocation of parental rights and responsibilities, a complaint for child support, or a parentage complaint. So you want a complaint to establish paternity. And then of course in divorce and dissolution, that's where child support is established in the domestic court. The Child Support Enforcement Agency can establish child support by anybody coming there and saying, I want to establish child support or I want to establish paternity in child support. And they will do that as an administrative agency. When they do that, it can remain an administrative order until the children are emancipated. Or someone can ask to have it brought over to court because they want it modified or they object to their establishment of it. And that's where it comes to the 3 CSEA magistrates to make a determination on those objections. So does anybody here, you don't have to say who it is, have like a family member? It seems like every time you go to a holiday dinner, someone says, oh, my niece is pregnant and her boyfriend doesn't want to pay child support. Has anyone ever gotten that conversation? So in this way, your party trick is going to be you'll know where to send them instead of answering their questions, and you can just stop the conversation and quit talking about your job while you're at dinner at Christmas. So they can go to their county child support enforcement agency and request that either the paternity be established or if that's already established, the child support be established. And that way you can clean your hands of that family member, not deal with it, and send them to someplace where they know that it'll get taken care of. And I don't mean clean your hands of them permanently, just for that situation. They also might say, people will say to you, well, I signed the birth certificate. But in Ohio, that doesn't establish paternity. So there has to be either a registration with the paternity or through a court order. So signing a birth certificate doesn't automatically make you the dad. And a lot of times I have to establish paternity and then change someone's name on the birth certificate because I wasn't the right person. So that doesn't establish paternity. Excuse me. Sort of a little tidbit of information is if somebody has registered with the central registry, it's like boyfriend, girlfriend, they have a baby, boyfriend says I'm the dad, he registers with, or mom registers him as the dad with the central registry. They have a certain amount of time where they can object to that, and if they don't, then they're kind of stuck. I mean, there's more complicated and complex laws that address the ability to contest paternity later down the road, but in that way, again, if you have a nephew whose girlfriend put him on the birth certificate and then registered him with the central registry, he needs to know that there's a certain amount of time that he has to object to that, or else he's going to be the dad de facto. So again, there's some other things that are more complex that we probably won't get into today that people can contest that, but yeah, sure.
How do you register
That's a really good question. I don't know, because we just call the central registry to verify that somebody is registered. Now, I know that the Child Support Enforcement Agency, when they establish paternity, they send that information to the central registry and get that registered. So I'm guessing that that's how it happens. You have to go through CSEA to do it. So, yeah, I'm limited to the stuff that happens in the courtroom, and then I deal with it after it happens over there. So I try to know as much as I can, but, yeah, a lot of times I don't know what they do over there. But they do establish paternity. They'll schedule genetic testing, that sort of thing. So, good question. So, child support. Once paternity is established, child support can be established. If it's established through the agency, that's called an administrative order. And again, that can remain in place until the child emancipates, unless somebody wants to bring it over into the court for modification purposes. They can modify it over there as well. I'm not wondering if I'm following this. Yeah. So if they set an administrative order and somebody doesn't like it, they can object to that and file a complaint to set support over here, over at the courthouse in front of one of the CSEA magistrates. And those are what we primarily deal with, are these objections to administrative orders. Or the Child Support Enforcement Agency can modify an order. So if someone got divorced and they had 3 kids, and 3 years after they got divorced, they decide that one of them decides they want them to review child support, but they don't want to pay the money to file a motion to modify child support, they can go to the Child Support Enforcement Agency as long as it's been 3 years since their last order, and they'll review it. They'll ask the parties to send in information, and they'll issue a modification of that support order. And then if they don't like that, then they file an objection, and those come to us as well. And so then we handle those on a de novo basis. Basically, it's like a do-over. Then we have to redo the case. It's kind of a good way for people to get their child support reviewed if they don't want to pay them. I don't even know how much it costs to file a motion, Maurice, so you know that. How much it costs? $150. You can save yourself $150 by going to the agency and asking them to review your child support instead of filing a motion with the court.
Is that something different than the 3-year?
Yeah, well, so if you go to the Child Support Enforcement Agency, they won't review it within 3 years of a current court order being in effect. So let's say, yeah. And so then if they review it and they say, we think it should be X, then you have 14 days to object to that and bring it over to the court and have the court review it.
The initial court order, the initial administrative review for child support was the initial child support order. Okay. But it stays administrative.
Correct.
Again, a failure to comply with that would not be contingent.
It would be, actually. That's a good question. So,
not a court order.
But it will get approved and adopted and made a court order, and then you're found in contempt retroactively on that one. That's one of the few ways that you can do that. So, yeah, that's a good question. If someone is not following the administrative order, that's where the Child Support Enforcement Agency's attorneys come in, and they can file a complaint to approve and adopt and for contempt. So they ask the court to approve and adopt the administrative order, and then they can be found in contempt. There's a statute that says that they can be found in contempt for violation of the administrative order in court when they bring it over as a complaint. Anybody have questions about that? That's a little bit convoluted. Yeah, sure. No, I'm glad you're asking.
So when when a person's license gets suspended
Correct.
for failure to pay child support, what's the process? I mean, how does that happen?
How do they do it, or how do they get it undone?
Or how do they do it? Like, what happens to get to that point where their license gets suspended?
So that's an administrative agency question. When somebody's got enough arrearage, then they can, and that's an administrative law, and I don't deal with the actual administrative code with those, but the administrative code basically says at some certain point in time they can just seize your driver's license. I just actually had a case yesterday. Is today Wednesday? Yeah, yesterday, where a man came in and claimed that it was against his constitutional rights to not be given fair notice to have his driver's license taken away when he wasn't paying his child support. And, that's all a very interesting argument, but, that doesn't work. It's part of the law if you don't pay your child support. Now, I think there's a valid argument there that seems to be an infringement on your rights to just without notice just take it. But the implication is you have notice. You have noticed that you have a child support order, and if you're not paying that order, then there are consequences. And so I think that's their. Yeah, I had the governor's office had somebody there yesterday defending that, and I was just like, this is not for me to deal with. I'm just dealing with your child support. You're going to have to ask somebody else to fight over your constitutional rights and quit having, to start paying your child support. So, yeah, that's a pretty harsh thing. But then again, someone being $50,000 or $60,000 in arrears in child support is pretty hard on the other parent, and they can come in and have a modification if they have an inability, and that's a defense to a contempt. If you have an inability to pay, that's absolutely a defense to a contempt. So I can reinstate people's driver's licenses if they come into me and they say, it's a contempt action, I couldn't pay, this is my defense, can you reinstate that? Then I can do that by court order. Yeah.
If you have an inability to pay, wouldn't one of the prerequisites should be maybe that if you got an inability to pay, then you should be asking for a modification of the order first. If you fail to do that, then you're bound by the order. So why would the inability to pay absolve you of the consequences of the existing order?
Right. On paper, that's perfect. But if you have someone who's lost their job and they're living in their car and you're saying, why didn't you go down there and call them and read, they're trying to figure out where they're going to get their next, where they're going to park their car so they can sleep that night. They're not thinking modifying their child support. They're thinking, am I going to eat tomorrow? And so when we find an inability to pay, or maybe somebody was in a car accident and they've been in the hospital, or, during COVID, people lost their jobs and they didn't really know how to navigate the system, as long as they didn't let it go on for 10 or 15 years, we have real life problems that we understand that people just can't address in the moment. So we try to, there's law and there's equity, and we try to balance those two things together. So, so on the objections, so when someone files an objection, they don't like what they did over at the agency, and they come to my courtroom and they say, I don't think that was right. And then I say, okay, well, this is a trial. What did you bring? Well, I didn't bring anything. I gave them all my stuff. And in their paperwork, which nobody reads, they have a form that says you have an order that says you're supposed to bring your last 3 years of income tax returns, your recent pay stubs, any daycare costs, any health insurance costs, all the things that would go into calculating the child support worksheet. And so then we continue it so they can do that. I don't find people in contempt unless they refuse to bring those things. They just usually haven't read their paperwork and they just don't bring it. So no, I don't get anything from the Child Support Enforcement Agency. I know they've already produced those documents for them, but they have to bring them to me, just like we do have to produce evidence in court as exhibits and those kind of things. So we do a lot of continuances for just that. The other thing that comes up a lot since COVID is that a lot of people want to have a Zoom hearing. They don't want to come to court anymore. And I will do a Zoom hearing under two circumstances. If the parties are just coming for a preliminary hearing and they want to know what's going on and how do I, what do I need to do and is there going to be a trial? Or if they say they have an agreement and they just want to acknowledge their agreement on the record, I'll do that. I don't do contested trials on Zoom. It's just a nightmare. They're supposed to email their exhibits come in and sometimes you print them off and they're this big on the paper, or they don't print them off, they don't send everything in. Oh, I thought I sent that, let me find, we did it when we absolutely had to do it during COVID and we don't have to do that anymore. So I'm not doing trials on Zoom. Periodically I'll have to take testimony on an uncontested, like a default case. If someone comes in and let's say mom lives in the state of Washington and they're trying to establish paternity and we need mom to testify and dad doesn't show and it's not contested, it's default, I'll let mom show up on Zoom and take her testimony on Zoom. But when it comes to, during COVID, I had people trying to cross-examine each other, pro se parties on Zoom, and it was just horrible. And I just was so glad when we stopped doing that. Okay, let's see. So I think I already talked about when the cases come to me or when they go to another magistrate. Objections to the CSEA recommendations. Periodically, if people have two cases, this is something that comes up in domestic and juvenile court, someone will have an administrative order and they'll modify that order. And then someone will file in front of me and say, I don't like the modification they had. And by the way, I also filed a custody case in front of the juvenile magistrate. So they'll have two cases going on at the same time. Sometimes that juvenile case also has, technically, because of the way the complaint was filed, has jurisdiction over child support. And so it can get a little bit tricky. And people sometimes will agree to dismiss the objection in front of me and not have that administrative order come in as a court order, and then they'll file what they call a motion to approve and adopt and modify the administrative order in the other case. So there's two ways that you can get an administrative order into the court. Yes?
I do have a question.
Yes.
It's actually the opposite. What happens, I had a case where a person had an administrative order and then they filed a custody on top of it.
In the administrative?
In the objection case.
Yeah.
And they came back like years later, about a year later, and filed a custody case.
Yeah, that would get dismissed off of that because the administrative order, the approval and adoption of the administrative order becoming a court order, only has jurisdiction in the complaint to address child support. So if someone files a motion for custody in that would be dismissed for lack of jurisdiction because that case doesn't have, in the complaint, there was no notice of custody, and so that's not what's pending before the court. Does that answer your question?
That actually helps me a lot.
Okay.
What do you think?
So if you want to file a complaint for custody and you already have a case with an administrative order, there's two schools of thought that you can combine those cases, and they call that consolidating the cases. We used to do it all the time. There are certain powers that be that say that that's not possible and you can't do that, and then there are others that say that's fine, we should do that. So I can't give you any direction on those. It depends on who it comes in front of, and they're never me. They're always one of the judges or one of the custody-only magistrates, whether or not they want to accept the consolidation. But I think ultimately it's the judges that make that decision, and I have no idea what would happen depending on what judge you pull on those cases. What you cannot do is in a domestic case, a DR case, you cannot consolidate a DR case with a JU case. And so I'll give you an example of when that could happen. I had a case where there was a divorce, two children in the divorce case. One child was born before the marriage, but dad was served by publication. So they couldn't establish paternity of the child that was born before the marriage because they couldn't get proper service on the dad. So that child was kind of hanging out there. And so the Child Support Enforcement Agency filed a complaint to establish paternity and set support, and then they did find dad. So they found dad, they established paternity, and they set support for this other child. Same two parents, two kids, two different case numbers. One's in the divorce case number, one's in a juvenile case number. So then someone filed a motion to consolidate those two case numbers, but you cannot do that because one's a domestic case number and one's a juvenile. They're different clerks. It's different altogether. So that case was kind of a tangled mess for a little while. Then CSEA tried to do an administrative modification and said, we'll just administratively stick the two kids together on the same order because that's easier for us. But then we had two case numbers, and so you can't do that either because unfortunately, they just had to be dealt with separately because of the way that case came about. Okay. So let's see. So the other thing that can happen, and along those lines, is that if someone gets an administrative order and they object that and come to me and they don't like the administrative order, and I make a finding that it's actually correct, it should stay the same, I can choose to not accept it and make it a court order. I can say, no, it was right, and I'm going to leave it over there. And my main purpose for doing that is if someone does file a complaint for allocation of parental rights and responsibilities, then they can file a motion to bring that administrative order into that case, and those folks only have one case number running at the same time instead of two separate case numbers. The problem with having two separate case numbers is one's on the custody case, one's on the child support case, and then somebody 5 years later says, I want to get more visitation, and they accidentally file under the child support case, and then 3 months later they have a hearing date and they come in front of me and I'm like, you filed this under the wrong case number, I'm dismissing it, you got to start all over again and go to the other case. So we do whatever we can to try to keep people with one case number so that they don't have that confusion down the road on their cases. Let's see. So logistically, child support, I've been in practice for 30 years. I've done child support either in private practice as a staff attorney or as a magistrate for those 30 years. For 30 years that I've been in Franklin County, the child support enforcement magistrates have never had a dedicated space. So like they might have a certain couple of courtrooms for a couple years and then they get moved. When I first started practicing, you had to go to assignment if you had a child support case and say, where's the CSEA magistrate today? And they'd be in a judge's courtroom when the judge was on vacation, or they'd be in a magistrate's courtroom. So that it's hard to find sometimes where the CSEA courtrooms are. So it keeps us on our toes. Right now we're in the juvenile, they call it the Juvenile Intervention Center. It was formerly the Juvenile Detention Center. There are 2 courtrooms there that were used for the preliminary hearings for the kids who were locked up. And they've moved to child support there this past year. And I don't know how long it'll stay there. But if you're looking for the child support magistrates or the child support courtrooms, the best thing to do is to contact the assignment office and say, where are they? Because it could be different. You know, I might find out next week I'm somewhere else. So it's just a little bit, I think because our dockets typically consist of attorneys from the agency most of the time, they feel like it's easier to move us around because those folks can follow us around instead of having random lawyers. And random lawyers, plenty of them come in front of us, but on a daily basis we have the same people. Those are the CSEA attorneys. So let's see. And I put down here, in case anybody needs to know, so there's 3 dockets, CSEA 1, CSEA 2, and CSEA 3. I've identified which magistrates are attached to each of those dockets and who our court officers are and their phone numbers. The other thing that's interesting about child support is there's a thing called the liaison's office. It's on the 5th floor. That's been there for quite a long time. If you have a question about child support, like you need a printout from a case because you're going in on a contempt and you want to know what has my client's payment history been, you can go to the CSEA liaison's office and request that printout. They can get the things from the CSEA because it's across the street, and there's an understanding that that can be sort of burdensome for people to have to go over there and then come back over to court. They're also there to file the objections. So if someone gets a copy of their new court or their new administrative order that says your child support has changed, that person wants to object, they go to the liaison's office, and the liaison's office helps them fill out the paperwork to file their objection, and then they are the ones that set it on our dockets. So they play a really big part. They also do service for people. So if someone files an objection, they're the ones responsible for sending out the service on those cases. So they play a pretty large part in getting our cases on our dockets and keeping the public as well as the bar connected to the Child Support Enforcement Agency if there's any information they need or any questions that people have. Let's see. So I indicated that you can only ask for a modification of support every 3 years, but that's only administratively. You can file a motion to modify your child support at any time. If you were in court yesterday and you got a decision that says your child support should be X and you don't like it, and you object and the judge is like, too bad, that's what it is, and then you file an appeal and the Court of Appeals says too bad, then you can come back the next day and file another motion to modify child support. People do it.
Would it have to be based on different factual circumstances?
Yeah, and the law says,
circumstances?
yeah, the law says that there's got to be a change of circumstances to modify the support. So when people do that, they typically will get dismissed, but that doesn't prevent the other party from being harassed by having to come down again and deal with it, and sometimes hire a lawyer to deal with it. So it's the access to the courts. Everybody you can file whatever you want, whenever you want. I had a case as a staff attorney where a guy had filed 56 motions on the same day. They all had some different thing in them that made them unique. And I had to go through every single one of them and address the issues and dismiss them and tie them off. So yeah, you can file, I mean, you have to ask one of the litigants. We aren't allowed to do this. The other litigant has to, which is painful. Ask the Supreme Court to have someone designated as a vexatious litigator. Lawyers can do that. Parties can do that. We as the court, even though we're the ones taking all the abuse from the motions, we're not allowed. We don't have standing to have someone labeled as a vexatious litigator. It's just the parties, because we're supposed to be available for whatever.
You think 56 motions would do it though? Same day.
You would. And those weren't the only ones pending. There were like 23 other motions pending. That was just that one day that those got filed. So, and again, we tried. And the Supreme Court said the court cannot request that someone be labeled a vexatious litigator. It has to be the other party or counsel for the other party that has to request that, because they're the ones that have to say that this is a problem. You're the court, you're there, you're supposed to deal with whatever happens. So if you ever think you want to be a judge or a magistrate, just remember that. So I think those are just the basic overview. I can tell you that for 13 years I also worked in juvenile court handling abuse, neglect, dependency cases, and so if anybody had any questions about any of those, child support can be established on an abuse, neglect, dependency case, and I get those through the agency all the time. The Child Support Enforcement Agency can file for child support if there's a child who's receiving any kind of public assistance. And if the children are in the care of Children's Services, then they will file against the parents for child support. Those cases used to be heard by the fifth floor magistrates who do the abuse, neglect, dependency cases, and just in the last several years we've convinced the court that they don't want to do child support cases because they don't even understand child support law. So it helped them out to get those off their docket, and now we handle those cases. Yeah.
When you have a contested trial on child support, do the rules of evidence apply?
Absolutely. Yep. And almost exclusively pro se parties. So we just had a magistrate seminar this year on how much are you allowed to help pro se parties present their cases, and it's really just painful not to help them. I mean, it's just hard to get your evidence in. So we try to be as fair as possible with both parties. We mark their exhibits for them. We make copies for them. We rule on objections and give brief descriptions of what a real objection is. Like, I'm going to overrule that objection is not that person's lying. That's not an objection. Objection would be something like that is hearsay or that document is not authenticated. We don't give them a whole treatise on the law, but we try to kind of corral them so that we're not there all day. And then we ask basic questions. So, yes, you want to present your case, but here's the minimum I need to know. What's your name? What's your address? How many kids do you have? How old are they? Do you have a job? Do you get paid? How much do you make? You know, like I ask this basic set of questions for pro se parties, and then I say, and then now you can tell me anything else you want me to know, and then I have to add about the calculation of child support, because they want me to know everything about the other person, and I don't want to hear about it. So, yeah. Yep, they do. Does anyone ever done abuse, neglect, dependency case? You have.
And not here.
Not here.
In Northwest Ohio.
Oh, okay.
But I was a county prosecutor, so
Oh, right.
part of my job was doing abuse, neglect, dependency cases. But that was a long time ago.
So was part of your job contempts for child support?
No.
Okay.
No, another attorney handled those.
Okay. Okay. So is everyone here practice in Franklin County?
Yes.
Yeah? All right. You don't have to tell me if you don't want to, but can you guys tell me what kind of law you practice?
I'm a prosecutor.
Okay.
I'm private attorney working for, and I'm actually on all the work point lists.
Yeah.
So I do A&Es and contempts and whatever comes.
And child support
Yeah,
and divorce
child
and
support.
dissolution. Yeah. How about?
I do more criminal stuff. I do a lot of common pleas, second foreclosures also.
Okay.
So,
I'm always looking for a second career. I want to know what people do.
and a lot of times I'll be co-counsel because a lot of attorneys don't want to have to go to trial. And I don't have a problem doing it.
Sure. Yep. Yep.
I do criminal defense and common
Right. Recognize you. Anybody else?
Immigration.
Immigration law. I just had someone ask me today if I knew an immigration lawyer, and I said no. So I'll get your name.
Yeah, only immigration, that's all I do.
Okay. And do you guys work out of the federal courthouse mostly?
No, it's family business-based immigration.
Oh, okay.
Family green card applications.
Oh, wow. Interesting. I bet you're busy. Yeah, cool. I'd love to hear what else people do. Yeah, that's cool. Anybody else want to tell me what you guys do? Civil. Okay.
Same, I do civil and some real estate.
Okay, cool.
Reformed family lawyer, I'm semi-retired.
Right. I had lunch with two fully retired yesterday. I had to go back to work. They just stayed. It's great. Cool. And what do you do?
I'm not an attorney.
You're not? Oh, cool.
I'm not, yeah, but I'm a legal interpreter. That's why
Oh, okay. So let me address that. We have interpreters every day in our courtroom. Yeah. And the range of languages is unbelievable in Franklin County. We need Bantu interpreters. We need obviously Spanish interpreters, Somali interpreters. We have Chinese. We had Italian the other day, which is not as common, and French. I mean, it's just, we're really lucky that we're a big county because we have the resources to be able to do that. And we didn't always. I mean, we used to use the language line, and we'd have this little thing that looked like a spaceship that was, we'd call them and they would interpret on the phone, and it was very difficult to hear. So yeah, I'm so grateful for the interpreters. It's, oh my gosh.
my language pair is Mandarin Chinese and English.
So Mandarin Chinese is really, really uncommon. We don't have very many Mandarin interpreters.
There are two certified
Yeah.
Mandarin interpreters on the roster, and there is another provisionally qualified.
Okay.
These three are in Ohio.
Oh, great.
Yeah, but there are other, I think there's 3 or 4 others that are in other states.
Yeah, that we can use the language line.
Rosters, yeah.
Right.
We can contact.
Yep.
And then in California and Florida, I think they're kind of in a different system almost.
Sure.
So there are more people over
Sure.
in those areas, but they are not, I don't think many of them are on the Supreme Court of Ohio's roster.
Right.
People, I guess people will find a ways to contact them, because I sometimes get contacted by other states.
Oh, wow. Sure. I mean, it's not a super common, because unless you're a native Mandarin speaker, my understanding is it's almost impossible to learn as an adult. It's difficult.
It's difficult. I guess it's just, it's kind of like people think English is difficult to learn.
Oh, I bet.
But if you're born into it, then
Right.
it's natural, and if you learn it the natural way, just like kids learn
Sure.
the language, just by mimicking, then it's easy.
Right, right.
Yeah, I think people find it difficult when you come to the writing system.
Oh, yes.
Because it's not like English, you write what you hear.
Right.
It's really in characters.
So my question is I've always had this question I've wanted to ask an interpreter, and I haven't. Sometimes they're certified in interpretation and translation, and sometimes they have to sort of translate the pleadings for the parties so that they can read. That takes a very long time, right?
Yeah.
Yeah.
We call that site translation. That means something you translate outside in court.
Right.
Looking at it and translate. But sometimes just reading the language is hard to interpret than oral language.
Right.
And so it will depend on the interpreter whether they would do it. Depending on the document, the complexity of the document.
Sure.
And sometimes it may pay to have it done outside of the court.
Ahead of time so that they can have it in their own language written down. Yeah, yeah. I wondered about that. And I don't know. Yeah, go ahead.
It just made me wonder whether during COVID you had a contested pro se Zoom trial where an interpreter was necessary.
I did.
Oh.
I did.
That was a long day, huh?
Yeah, they were from Afghanistan. And so we had the 2 interpreters. I mean, it was like the Brady Bunch on the screen. And it was really challenging because different cultures have different understandings of etiquette. And some cultures, it's not, like, if you've never been to the United States and been in a courtroom, you don't understand how it works. And then the fact that none of us understood how it was supposed to work on Zoom, that people would be talking at the same time. And when you're on Zoom and you have someone talking and then the interpreter interpreting for them and then the other interpreter is interpreting for the other person, that's a lot of noise coming out of your computer, and it's really hard to know if people are really hearing what they're supposed to be hearing. And so there was a lot of, ninja muting people and letting them back in, and it was really hard. It took a really long time, and they didn't know how to upload their income information, and it was that's one of the reasons I'll never do trials on Zoom again, because I just don't feel like people get the proper access to justice. You don't get the ability to present your documents in a way that is clear, and it's hard to read people's, can I tell if this person's telling the truth? They're sitting in a room that's sort of dark and I kind of can't see them, and their kids are screaming in the background, and it's just like, how do I know? It's hard to tell. And who all had to do that when they were during COVID? Did you guys do Zoom hearings? Yeah. Anything contested? Anybody? Yeah.
It was terrible.
Yeah.
And one of them, I was pretty convinced the witness was being coached by somebody else. As they're looking, and then they answer.
Oh, I mean, I've had people literally be like, they're sitting there and you hear someone say, "Just tell her now." Who is in there with you? You are in a courtroom testifying. You can't say that. Yeah.
I didn't see that so much as we had one witness that was clearly watching somebody else, telling them what to say.
Yeah.
Very obvious.
Right. And when the kids were involved, I mean, if you're testifying in court about, because one of the things that we have to do is when we establish paternity is there's a line of questioning, Did you have sexual intercourse with this person during the months of January, February, March of 1996? And they're like, I don't want your 10-year-old sitting there with you while you're testifying about this, And it just seems inappropriate. So can we not do that? Send your kids in the other room. Or when they're driving and they're on Zoom and you're like, I'm going to pull over right now. And it's like, I don't want to see that. Yeah.
If they're on Zoom, and let's say they're in their home or something, and you're seeing everything, okay? If you see something, an activity or something that's going on in that room, nobody's presenting as evidence, but you see it and you think that it's relevant to the case, how do you handle that?
I mean, I've never had that happen. Like, someone's sitting there and they're like, they say they're broke and their doors open and their Porsche's in the driveway or something like that. Like,
or 12-year-olds smoking pot or something.
Well, I mean, I'm a mandatory reporter. If I see that, I have to call Children's Services and tell them. So, yeah, I mean, I have to, no matter.
As far as the particular hearing itself goes, can you do anything with the information that you visually see, as far as it being part of the record?
I mean, I've never had to address that, so that's a good question. I mean, I don't know. And again, if it was something that I saw that required mandatory reporting, then I would do that for sure. I think sometimes you can be biased by what you see and not put it in your decision. I mean, yeah.
And it has to deal with when we go on a record on Zoom. Is that recorded? Is it the videos recorded and you guys?
No, just the audio.
Okay.
Just the audio is recorded, and when we started, it was being recorded through Zoom, and then it was being downloaded to our court reporters somehow. I wasn't involved in that part of it. That's technology. I don't deal with it. But we had to hit record on the Zoom, and then it changed where sometimes we were having hybrid hearings where maybe you were in the courtroom and 3 people were in the courtroom, and then you have a big screen and someone was appearing by Zoom. Then you'd have a court reporter or a stenographer in there recording that part of it. So I don't think that we're recording on Zoom anymore. I think there's always a stenographer or a court reporter, but the juvenile court that does the delinquencies and the abuse, neglect, dependencies, they do it totally differently, and I don't know how they're doing it. So that would depend. I don't know if I'm supposed to go to 115 or just 1. Do I have to go to 115? Okay, sorry.
I had a question.
Yeah.
Actually, because of something you said right at the outset. You talked about how juvenile records were not public, domestic records were public, and for me, in the civil context, for so many years, all I had to do was be able to open up the clerk's website, click on the PDF, and see what I filed, see what somebody else filed. That's not possible in the domestics. The record
In juvenile court. Domestic is completely available, but it's not?
So whenever you go on the domestic website and you'll say that someone filed for a dissolution is no longer valuable, the PDF.
Right, but this image, you can see that someone filed a complaint, filed an affidavit.
Oh, but you can't open the
On
image?
civil side, there's no PDF icon you can click on and look at.
Unless you're an attorney of record.
Oh, okay, yeah, sure.
Yeah, but
So,
domestic is not.
I'll explain something to you. About 13 years ago, I started working for the court. I was in private practice. So I understood what the courthouse looked like from out here. And now I know what the courthouse looks like from in here. And since then, we've started e-filing, we've started being able to access records online, those kinds of things. And I've never had to do that from the outside. So I don't know, except for what attorneys tell me or people tell me, what they can access. Because I have access, obviously, to all of it.
But it appears now that if I want to see if someone applied for a dissolution, that I need to go to court and say that I would like to review the file, because it's public record still, but it is not available online unless the, I'm
Okay.
registered as attorney.
They don't, in divorce cases, they don't get
Yeah.
certain affidavits are not, you can't get it.
Yeah, right.
So you can just see the
name.
the record of what's been filed and when it's been filed, but you can't open the PDF of
Right,
it.
right.
You can't go get a copy of it because stuff like the affidavit, financial affidavits
Yeah, you can.
have like bank account numbers and
Right.
stuff.
Personal identifiers.
Yeah.
Right.
So
Okay.
they don't let them.
Sure, I can totally understand why they would do
Yeah,
that.
when a complaint is up, let's say that no personal information on that is not valuable
Yeah.
anymore online.
Interesting. Yeah, I didn't know that. I just know that juvenile court, you can't access any of it.
Yeah, that's true. I mean,
Yeah.
you could never do that, but
Right.
I think that 8 years ago or 10 years ago, you could see, basic information.
Right. Okay.
You could open up the motions and stuff like that. but
Right.
You cannot do it anymore.
I'm going to guess, because some of it has to do with personal identifiers, and I can tell you right now that our computer system, our e-filing system, our website is so outdated that if there was a way to have you get access to some of it and not others of it, they don't have the ability to do that. So they probably either had to shut it all down or open it all up, is my guess. There's been a push for the last 6 years, 5 or 6 years since before COVID, to update those systems, and, who knows?
Well, yeah, I do know, since I was talking about the civil side, that usually there are PDFs you can look at, but let's say you get an order to seal something.
Right.
You click on it and access denied comes up.
Sure.
So the clerk can
Yeah.
somehow go in for an individual filing and pull it back and prevent it from being accessed.
Right.
Right.
And a lot of people will do that in domestic court. They'll have their file will get sealed for specific reasons, and even if you go in, you can't get their file. Even they can't get their file without a court order.
You don't have to unseal it.
Yeah. Yeah.
Unseal.
Mhm. And so, probably because some of that is sensitive information, they had to make a decision about whether or not to shut down the access to all of it, or to open access up to all of it. Because, like I said, our computer systems are so outdated and so not user-friendly that I'm guessing that that's the limitation, and that's probably why that happened. I mean, that's my guess. So, yeah. In the juvenile court, I know that if you want access to the records, is this still the case, that you have to go in and fill out a form that says you're the attorney of record, or at least indicate and show proof that you're attorney of record before you're...
We're not, what we actually file, we have to file everything electronically without even going to the clerk's office.
Anymore.
It's a CPO or something of that nature. And then, they won't accept
Paper filings.
Paper
Okay.
filings, yeah. And then once we get that, we have access to the electronic DECF e-filing system.
Okay.
And we can see it 24 hours a day.
And if you withdraw as counsel, then are you kicked off of that? Okay.
Yeah.
Well, there you go. That's your updated information on how juvenile court works. So, and we do have 2 separate clerks, the juvenile clerk. And the other thing that can get a little bit tricky, and it's an interesting thing, I found this out in private practice, is that the custody-only cases are basically domestic cases because it's a custody and support case. But because it has a juvenile case number, they're treated the same in the clerk's office, so there's no access to them. And for a long time, they were operating under the juvenile rules. And the juvenile rules say things like, you can't take a deposition without leave of court in a juvenile case. But if you have a custody case and someone notices you for a deposition, you don't think twice about just showing up for the deposition because you don't think that you're under the juvenile rules. This has changed since then. But when I was in private practice, I had an attorney file a notice of deposition, and I didn't show up for the deposition because she scheduled it for a Sunday afternoon, and she was just being very difficult, and I just said, my client can't be there, I can't be there, and so then she filed a motion to compel. And I had an older, more experienced attorney come over and just say, let me take care of this for you, and he was just like, juvenile rules say you didn't get leave of court to file a notice of deposition, and they've since changed that. Because
Excuse me, when did they change that?
7 or 8 years ago?
No, because we just had a case.
Yes, we did.
Yes.
Okay.
With Martello
Right.
on juvenile rule 24, and it was about interrogatories.
Right.
About
They're
discovery.
not allowed to be filed under 24. And that
Under the
was-
juvenile rules, but the domestic local rules now, I think our domestic local rules say that the domestic rules shall apply to custody-only cases.
that's
okay,
not-
so-
That's not the way they're doing it.
No,
So how are they?
You have to, in order to file interrogatories in a custody case, in a JU case,
Right.
you have to get leave of court for interrogatories. You can do depositions, you can.
So they just changed it for depositions
Yes.
and for
depositions, but you can't file interrogatories without leave.
and for production of documents, you can still do that.
Right.
You do
Yeah.
that, yes.
Yeah, but not for interrogatories?
Yeah, don't know
Because it's
why.
not in the juvenile rules.
Right.
Juvenile rules doesn't address interrogatories, civil rules, and civil rules control divorces.
They do,
Yeah.
but there was the push to have the civil rules be applied to the custody-only cases.
They don't, matter of fact, that's a Roger Warner, that's a Roger Warner thing.
Okay.
He's the one that caught me on it, and I caught.
Okay.
And that happened.
Yeah, so that's definitely something to be aware of when you have a juvenile custody case, that abuse, neglect, dependency, and delinquency cases are such different creatures than a juvenile custody case, but they are treated similarly because of the rules.
Because if you really read juvenile rule 24, it's so much has to do with delinquency, abuse, neglect, and almost nothing to do with like what we were doing.
Not almost nothing, absolutely nothing.
Absolutely nothing. That was one of the reasons why I'm like, no.
Yeah. Yeah.
But,
Yeah.
that happened.
It's one of the unfortunate quirks of having those cases be
This year,
juvenile.
that happened this year. Yeah.
Yeah. So, that's an interesting little thing that happens in the juvenile / semi-quasi domestic cases. So, has anybody had anything come up? I know I kind of mentioned that when you have holiday gatherings with your family, does anybody ever have that happen to them before, where you've had someone come up to you, or even at a party, oh, you're a lawyer, my ex is being such a bitch about this, and
Church, you go to
Church.
Catch you in the
Yes.
parking lot. You're just trying to leave with your kid to go to lunch.
yeah, yeah,
Let me tell you about my case.
yeah,
Call me Monday morning at 9 o'clock.
right, no. Yeah, I just had that happen to me last week. I know that you don't work in Perry County, but my friend's kid is in a horrible situation, and how could they do that? How could they let the dad visit their kid? I don't know. What should she do? She should probably call a lawyer. I tell people, even now, even if I wanted to, I can't give you legal advice because I'm not a practicing lawyer anymore. I'm a magistrate. I'm on the bench. I'm not allowed to give legal advice, but I can refer you to 3 people, and you can choose which one you like the best. And yeah. I'm looking for tips. What's your best way of getting out of those?
Can't help you.
I just can't help you. She's just straight up.
What we literally do is say, I really tell them, hey, my office hours are,
Mhm.
call my assistant, this is the number, I have a card, keep on.
I
Yeah.
just give them an hourly rate.
That's a good one. Hang on, that'll be $600.
Yeah.
That's a good
What's your
idea.
billing address?
That would be the best first question. I'm sorry, before we talk, can I get your billing address real quick? That's a good response. Okay, yeah. Does anybody have any more questions or any other questions about how all that works? No? Well, I hope that the disillusion checklists help you and the outline helps you. I hope those of you who tried domestic and juvenile and didn't like it don't ever get sucked back into it. Thanks so much. Thanks for your time. Yeah, I think we're pretty much done. Yeah? Yeah, thank you.